Mediation before appeals. This video will cover what is mediation, when to consider mediation, the mediation process, preparing for mediation, and what happens after mediation. Mediation is free. It is a process that looks at settling disputes or disagreements about education, health and care plans, EHCPs, and needs assessments. The process is intended to feel informal and does not require legal representation. It can be a chance to speak to the local authority about how they reached certain decisions and to look at any additional or missed information or evidence to see if they will reconsider those decisions. You would need to consider mediation if your appeal to the SEND Tribunal is about refusal of an education, health and care (EHC) needs assessment or reassessment, refusal to issue an education, health and care plan (EHCP) following an assessment, the description of special educational needs and/or special educational provision in a final EHCP, refusal to amend an EHCP following a review or reassessment, or a decision to cease to maintain an EHCP. You would not need to consider mediation if your appeal is only about the placement named in Section I of a final EHCP. You can also go to mediation about health and social care elements of an EHCP if they contain information about educating or training a child or young person. Considering mediation means having your rights and the mediation process explained to you by an independent mediation advisor. In Leeds, this service is provided by Collis Mediation Limited. The mediation advisor will provide you with factual and unbiased information about the process and answer any questions. Mediation is voluntary. You should not feel pressured into agreeing to mediation and should feel free to choose whether to proceed or not. If you decide not to go ahead with mediation, you will be issued with a mediation certificate within 3 working days that will allow you to register your appeal with the SEND Tribunal. If you agree to mediation, a meeting will be arranged for you within 30 days. The local authority must attend mediation. The local authority and any health commissioner representatives that attend should have the authority to be able to make decisions during the mediation session. Mediators must have sufficient knowledge of law and legislation relating to special educational needs and disabilities or SEND, health and social care to be able to conduct the mediation. All parties should be open and not hold anything back for a possible appeal to the SEND Tribunal. You will be given time to speak and to make your case to the local authority and any other parties about the things that you disagree with. Possible outcomes of mediation are 1. Full agreement is reached. Agreement is reached for all areas of dispute or disagreement. A mediation agreement will be drawn up and there will be no need to continue with an appeal to the SEND Tribunal. 2. Partial agreement is reached. Agreement was reached for some areas, but not for all. A mediation certificate will be produced and there is a right to continue with an appeal to the SEND Tribunal about any outstanding areas. 3. Agreement is not reached. No agreement was reached. A mediation certificate will be produced and there is a right to continue with an appeal to the SEND Tribunal. Preparing for mediation. In the mediation session, you will have the chance to explain what has brought you to mediation and what you are hoping the outcome will be. If you are worried about feeling overwhelmed or nervous, it could be helpful to prepare some notes to act as prompts, or even a statement or script that you could read from. You could also consider taking someone with you for support, or perhaps to speak on your behalf if you find yourself unable to. You could make notes about each area of disagreement and your questions. What are you asking the local authority to reconsider? Do you have any questions about how they reached their decision? What do you want to happen or change? What outcomes or changes would you like to be agreed? Prepare some examples if you can. Any evidence that supports your views? Is there any information or evidence, perhaps within any reports or documents, that support any changes or outcomes that you are asking for? Any new evidence or additional information? Has anything changed or has any new information been provided since the original decision was made that you would like to be considered? Our information videos on the different types of tribunal appeals may also be helpful when preparing for mediation. Each video looks more closely at how to record your views and gather supporting evidence specific to which local authority decision it is that you disagree with. If mediation is not successful in reaching an agreement, your planning notes could then also be used as part of your appeal paperwork. You would have the right to continue with an appeal to the SEND Tribunal if you have considered but decided not to go ahead with mediation, or mediation has taken place but did not result in a full agreement being reached. To register an appeal with the SEND Tribunal, you have 2 months from the date of your decision letter that provided the local authority decision that you disagree with, or 1 month from the date on the mediation certificate, whichever is latest. Further SEND information and advice on a wide range of topics is available on our website. Visit www.leadsendias.co.uk. On social media, search Lead Sendias. Other sources of information, advice and support about mediation and SEND tribunals include Contact for Families with Disabled Children, www.contact.org.uk. IPSI, the independent provider of special educational advice, www.ipsi.org.uk. SOS SEN, www.sossen.org.uk. The Government Information and Services website, www.gov.uk. And Collis Mediation Limited, www.collismediationlimited.com. Thank you for watching this video. We hope it was helpful. Other videos in this series include Refusal to Assess Appeals and Section I Placement Appeals.